AI in the judiciary. Latest news. The Supreme Court, in June 2026, released the draft regulations for use of artificial intelligence, AI, in courts, 2026, aimed at creating a governance framework for AI adoption in the judiciary. It prescribes general principles for AI's use and establishes an institutional framework to oversee it. Applicability: is it binding? The draft regulations are not automatically or uniformly binding. They will come into force for the Supreme Court on a date notified by the Chief Justice of India, and separately for each High Court, and courts/tribunals under its jurisdiction, on dates notified by that High Court's Chief Justice. Different provisions can also be implemented on different dates, allowing phased AI adoption suited to each court's needs. What role has been carved out for AI? Courts are required to actively seek opportunities to deploy AI systems that demonstrably improve access to justice, reduce delays, or enhance administrative efficiency. AI use is explicitly permitted for administrative and assistive functions such as case management, transcription, translation, legal research, document summarization, accessibility, and court administration. All such use requires written approval from the SC's apex body or the concerned High Court/Tribunal's AI committee, along with supervision by nominated court officers. Can AI decide a case? No. The draft regulations categorically state that no judicial outcome can be reached through algorithmic decision-making alone or solely on AI-generated information. Human judicial authority remains determinative in all adjudicative decisions. AI's role in decision-making, if any, is purely advisory and subject to independent human evaluation. What is absolutely barred? Certain uses are prohibited in absolute and non-derogable terms, meaning no authority can permit them under any circumstances. Risk scoring to assess flight risk. Predicting recidivism, the process of using historical, behavioral, and demographic data to estimate the likelihood that a previously convicted individual will commit a new crime or return to prison. Evaluating bail eligibility. Determining witness credibility. Predicting, profiling, or inferring future conduct of parties, accused persons, witnesses, or legal representatives. Submitting AI-generated output as independent evidence without full disclosure of its AI origin. Using black box, unexplainable, AI systems in matters affecting personal liberty. Transparency for litigants. If a court uses AI that materially assists it in case management, document analysis, or judicial administration, it must inform the parties involved in a timely, accessible manner. However, litigants will only be notified when AI has provided material assistance, not for every instance of AI use. Institutional and regulatory architecture. An apex body at the Supreme Court, comprising sitting SC and High Court judges, a MIT-Y official, and finance/cybersecurity experts, will set minimum mandatory standards and issue implementation guidelines. This body will operate through 5 specialized committees, while the SC and each High Court will form their own AI committees, backed by an AI secretariat. A separate research body, the Center of Research and Excellence on Artificial Intelligence, Core AI, will evaluate tools and track developments to support the apex body. Role of private vendors. Private companies can be involved only with written approval from the relevant court authority and must comply with mandatory contract terms covering ownership of and access rights to court data and AI outputs. A bar on using sensitive judicial data. A prohibition on retaining or fine-tuning models using court data without AI committee approval. No exclusive IP claims over tools built substantially on judicial data or public resources. Safety measures, a life cycle approach. The regulations mandate safety checks before, during, and after AI deployment. A technical and ethical impact assessment covering system architecture, training data, bias, hallucination risks, and cybersecurity. Some systems may require controlled environment testing in isolation before deployment. Post-deployment, systems face technical, legal, ethical, and cybersecurity audits conducted in-house, Source code and training data cannot be shared with third parties. Each court must maintain an AI register of approved systems and audit outcomes. Each AI secretariat must maintain an AI incident database, with mandatory 24-hour notification if a tool fails or is suspended. High courts must have an emergency fallback protocol to run processes manually if systems fail. Grievance redressal for litigants. Where harm results from a prohibited use of AI, an affected party can file an application with the court where the AI system was used. The court must provide a hearing and pass appropriate orders. High courts may design simplified procedures and complaint formats for accessibility, and this remedy exists alongside other legal remedies already available under ordinary law. Conclusion. The SC's draft regulations strike a calibrated balance, embracing AI for efficiency and access to justice while firmly safeguarding judicial independence, personal liberty, and due process. By barring algorithmic decision-making in sensitive matters and ensuring layered oversight, India moves toward responsible, human-centric AI governance in courts.